Welcome to the Regulatory Transparency Project's fourth branch podcast series. All expressions of opinion are those of the speaker.
And welcome to the Federalist Society's Regulatory Transparency Project's fourth branch podcast. My name is Elizabeth Dickinson, and I'm an assistant director with the Regulatory Transparency Project. And with that, I'll hand it over to you all.
Hi there. This is Wallace DeWitt. I'm a securities lawyer at a undisclosed location in Washington, D.C., but I am joined by two close friends, Brian Knight, a senior research fellow at the Mercatus Center of George Mason University. Brian's scholarship, as many of you will know, focuses on financial regulation and particularly lately the politicization of financial services, which I think in today's discussion of the SEC will be particularly germane. We're also joined by Jennifer J. Schulp, the Director of Financial Regulation Studies at the Cato Institute's Center for Monetary and Financial Alternatives, where she also focuses on the regulation of securities and capital markets. She is perennially testifying before Congress and is a former enforcement attorney at the Securities and Exchange Commission, recent co-author of the book Financing Opportunity, and a member of the SEC's Investor Advisory Committee, and perhaps most importantly, a former resident of my hometown in Illinois, where we both grew up. So today's discussion is is a look back on the SEC during the Gensler administration from early 2021 through the present, and perhaps a little look forward at what's to come given the results of the elections this week and the re-election of President Trump. This being a Federalist Society podcast, or any industry discussion of the Gensler administration, it can turn dark pretty quickly. I'd like to start the conversation with my own personal view of things I admire about Chairman Gensler, which I think we should, even as we might go into some critiques of his term, I think are worth mentioning. And in particular, this being a Federalist Society podcast, my mind goes to the Federalist Papers. And so in number 70, Hamilton introduces this idea of energy in the executive. I can't imagine any other leader of a regulatory agency within recent decades that has had a more energetic, in the Hamiltonian sense, role at the agency. The volume of rulemakings that he's come through with, the number of enforcement actions, the speechifying, he's an extraordinarily dynamo of a public servant. Now, we may disagree with the overwhelming majority of that, and I think that may come out in today's discussion, but it is worth noting that I sometimes think of Gensler as in a similar vein to Henry Kissinger or John Bolton or Donald Rumsfeld, or maybe Lina Khan is a good example at the FTC at the moment, of somebody who came in with a very explicit vision and damn the torpedoes, he went ahead and did it and got the SEC staff to go along with it. So I do think that there is that to say. Now, turning to Brian and Jennifer, I'd like to start our conversation with what you might call reputational harm to the SEC over the past few years. I think the best condensed symbol of this might be the fact that for the first time probably since FDR in 1936, the SEC and its chairman have been mentioned in some speeches by President Trump with regularity over the past 6 months. Not something that you typically hear about a relatively sleepy and technical agency. Brian, Jennifer, in your view, what are the headlines that come to you over the past 4 years from the SEC? What otherwise stated, what's the Gensler legacy look like to you? Jennifer, why don't we start with you?
Yeah. I mean, the Gensler legacy to me is largely one of overreach. And that's kind of a problem for the agency's reputation. And we've seen it across the board in many of the areas that Gensler has come in to tackle with his vision. Climate risk disclosures, our agency overreach looking a lot more like attempted environmental regulation than securities disclosure regulation. Refusal to create rules about cryptocurrencies while simultaneously engaging in a full forced enforcement campaign against them is agency overreach in a number of ways, including by looking to ban an industry when the SEC hasn't ever been given the authority to make that decision. And we've seen it in a lot of other areas as well. So my headline is overreach, but kind of from the reputational angle that you've been talking about, that overreach has resulted in a lot of blowback to the agency, not only in President-elect Trump mentioning firing Gary Gensler as a priority for his administration, but in terms of actual market participants being much more willing to take on their regulator. We've seen what has probably been a record number of challenges to agency rulemakings that have worked their way through the courts. The SEC does not have a great record on the ones that have been completed by the courts. And we've also seen a lot of industry participants suing the agency proactively, particularly in the crypto context, for clarification on rules that the SEC has refused to provide. It's pretty unprecedented to see an awful lot of proactive lawsuits against a regulator. And I would say I'm all in favor of suing your regulator. Don't get me wrong about this. That's good. It's a good check. We should do more of that. But when you are an agency and your stock and trade is in being able to get things done as efficiently as possible, the fear of suing your regulator, the fear that you're going to lose, probably needs to be a little bit stronger in terms of the agency's reputation in order to maintain their ability to do their job. So not just Gensler's overreach, but a lot of the things that have happened over the course of the past several years, I think bode poorly for the agency going forward. This has exposed kinks in their armor that is not going to redound to the benefit of the SEC in the coming years either.
Mm-hmm. So to piggyback off of that, and I agree with everything Jennifer said. I mean, I think part of the legacy that the Gensler SEC is going to leave for the agency is that it served to sort of force a collapse of the wave function, and it may end up with a lot less authority. Like the SEC may end up a diminished agency because there have been times where the agency would take sort of an edgy position about its authority. And for whatever reason, it wasn't challenged or the challenge wasn't successful. And maybe it's because the facts were really favorable to the SEC. Maybe it's because everyone kind of was like, well, okay, but how often is this going to come up? Maybe it's like, well, okay, maybe technically the law doesn't allow that, but you're like one half step out from what the law allows. It's logical that you think this. But now, having taken so many aggressive positions, so many sort of very aggressive positions on the SEC's own authority, and that coupled with a bunch of external factors like a judiciary that's more skeptical of agency power, the removal of Chevron deference, and frankly, the removal of sort of a culture of deference among the judiciary, the SEC's actual authority is going to be held up to a microscope in court, and it may end up functionally being recognized as smaller than what people generally thought going into it, right? So, let's take the climate disclosure rule as an example, which is up before the Eighth Circuit. We very well may see the SEC's ability to sort of take a flexible view of what additional disclosures it can mandate cut significantly. So not just, not just environmental things, but rather, no, here is the list, or here is, if you can't find something basically as a close cousin to the thing in the list, in the statute, it doesn't count. And so future SECs may look back on this period as the period where they lost a lot of discretion, and a lot of questions of discretion got resolved against them in a concrete manner.
Let's stick with the question of those litigation matters, Brian and Jennifer. Let me throw out a few statistics. I represent in my practice the Committee on Capital Markets Regulation, a sort of nonprofit think tank that represents Wall Street in Cambridge, Massachusetts. And they've been keeping statistics for the last 3 years on the substantive rulemakings under the Gensler administration. And so excluding things like the annual Edgar update or the annual, rise in the fees for filers and things of that nature, and focusing in on just material substantive attempts to regulate, we found that Gensler's had something like 49 substantive rulemakings over the last 3 years that far outstrips his immediate predecessors and only competes really with Mary Shapiro at the beginning of the Obama administration, where she was under 2,000 pages of Dodd-Frank mandates at the time, which is not the case here. Gensler's administration, by our count again, fully 82% of them were not statutorily mandated rules. And as both of you have alluded, they've been challenged at a greater clip than any of his predecessors as well. There was, by our count, 9 rules in multiple litigation matters have been subject to legal challenge. 3 of the 4 that have been decided were decided against the SEC. Several remain pending, including the 8th Circuit case that Brian just mentioned. I guess my question here is, that's obviously not a great record. It compares unfavorably to the last 3 chairmen of both parties. Looking forward to the next chairman, whoever he or she may be, what does the SEC do about those pending rulemakings? Does it abandon the position in court and say, these were not our rules, we're happy to have the courts strike them down? What's the strategy here, and what would you anticipate seeing from the SEC going forward?
I mean, my suspicion is that the SEC would try to reverse course on a lot of these rules. Now, depending on where they are in process and what their litigation posture is, their options may be somewhat limited. I would imagine at least, or I could certainly see them, say, moving for a postponement. Well, if there's a new GC, like let the new GC come in, let's review this. Let's, Your Honors, let's kind of figure out what we think about this. And if they come out and say, we now believe that this is not statutorily justifiable, the courts might, maybe they'll appoint someone else to argue that position. Maybe they'll appoint the Sierra Club or someone like that. But, it's hard to see those rules moving forward in any sort of meaningful way. And if, they do, if somehow, like, say, the SEC wins at the 8th Circuit, which I would find pretty shocking, it's going to be weird when the Solicitor General is submitting an amicus brief against the SEC's position at the Supreme Court. I think you're going to see efforts on the controversial rules, because like a lot of the rules the SEC did are not that controversial. We can quibble with them, but they're the type of things that the SEC generally does. But I guess the Gensler period is notable for how many controversial, and as you point out, not statutorily mandated rules they tried to push forward. It's one thing, Dodd-Frank super...
And simultaneously, too. So even if they're uncontroversial, industry still has to deal with all of them at the same time. Right.
And, that's another avenue that we might see. It's like, you may see in DERA a change where they start looking at the sort of cumulative burden of regulation.
And that's the Division of Economic and Risk Analysis. DERA is the acronym Brian just used. Please.
Yeah, the in-house economists, right? You may see them start to take that question seriously. And if you take that question seriously, that opens up a whole bunch of new avenues to both when you're doing new rulemaking, but also when reevaluating rulemaking about like, well, does this make sense, not just given its costs, but its costs combined with everything else? Now, of course, the other thing they could do is actually do, you might see an effort to try to do a somewhat more rigorous cost benefit analysis, or maybe ex post cost benefit evaluation. Like, well, we predicted this rule is going to cost X. It's been out in the wild for 10 years. How much does it cost? And if the number is significantly higher, that might prompt a review.
Yeah, I mean, my add to that is that we're obviously going to see an attempt to reverse course, but it's complicated. It very much depends on where the rule is, what the posture of the litigation is, how controversial that rule is. For example, the litigation against the tick sizes rule, that tick sizes rule was adopted 5-0 on the commission. I don't know that that's going to be something a new chair is going to look to reverse course on. And some of the precedent that has been created under the Gensler rule challenges have tied the SEC's hands a bit in terms of, I won't say tied because I think this is something that should have always been true, but it's been written by judges, in terms of having quick revisitations on rules that are on the books when there has been no material change to the circumstances surrounding those rules. So there's a lot of process here. Some of that process may very well spark new litigation, throwing more roadblocks up in just terms of SEC resources. So it's not going to be a January 20th, the SEC drops the pen on everything that had been done under Gensler, controversial or not. This is a much longer, much more complicated process that the agency's experts have to make a lot of decisions about.
Yeah, I think Jennifer makes a few really astute points there about the future of these rulemakings, and there was a case, and Commissioner Hester Peirce, was very vocal, as was I think Mark Ueda early on in the Gensler administration, where they did go back on a late, I think it was a November 2020 Jay Clayton rule that hadn't even come into effect yet. And the staff was basically, of DERA, Division of Economic and Risk Analysis, was basically told to do an about face, write a rule repealing the rule that hadn't even come into effect, which raised a lot of eyebrows. I think that cuts both ways, right? If the next chairman were to come in and try to slash and burn a lot of Gensler rulemakings that haven't really gone anywhere yet, that could be tricky. The other point that I often advise foreign clients on, which in the European or Asian contexts, there is a bit more flexibility under their equivalent of administrative law than there is with the SEC. And I often point out to our clients, deregulating at an independent agency subject to the Administrative Procedure Act is substantially the mirror image of regulating. It takes notice and comment. It takes an economic analysis. It takes 9 months or a year of, chasing the staff to get drafts up to the 10th floor of the SEC. And then it will be followed by the inverse litigation in maybe not the 5th Circuit or the 8th Circuit. Maybe it's the 2nd Circuit or the 9th Circuit, heaven forfend. And so I think it's really important to understand that unlike areas like where you can just President Trump can just dash off an executive order and reverse border policies or reverse military postures around the world. With securities laws and really any of the independent agencies, turning the ship around, to use the ubiquitous metaphor, really does take quite a long time. And it won't certainly be immediate. And as Jennifer points out, it's not going to be on January 20th or 21st or whatever. That's a good point.
Well, let me throw one more thing in there, too, because I think there's something important to think about in terms of kind of this turning on a dime. Because in order to make some of these changes that you're going to have to do through notice and comment or otherwise, you're going to want to have support. And there is oftentimes a preference for rule stability within the industry, even if that rule might be not the ideal rule in the first place. So rules become sticky not just because of the Administrative Procedures Act, but they become sticky as a practical matter in terms of once the industry has gotten in compliance or has gotten the compliance machine working to get themselves in compliance, a lot of times it's a fait accompli. That rule is the one that stays.
Great point. I mean, and to take an example that's come up in my practice recently, there's this pending Rule 13F2, which is the short selling rule, which has been challenged in the 5th Circuit. Oral arguments were in early October. The opinion could come down goodness knows when. I think the enforcement date or the compliance date is in early January. If you talk to subject institutions around the world, they've already devoted the resources to getting ready for that rule. It's a reporting rule. It's similar to 13F for long position reporting. It's a lot of internal systems have to be aligned and a lot of new jobs have been created around dealing with this new rule. The answer from the Fifth Circuit might be this is remanded or vacated. Who knows what they're going to say. That might, to Jennifer's point, working for a year and a half to get ready for a rule only to hear that it's gone out the window is not always music to the ears of the regulated party, and kind of goes to that question of the reputation of the SEC, that if you're going to put us through this whole rigmarole and then go away, yikes.
Right. In fairness, I think we need to give, if one wanted to be cynical, one could give Gensler a lot of credit as sort of a Machiavellian figure, in the sense he if his thinking was, look, we're going to flood the box, we're going to send as many rules through as possible. I understand some are going to get struck down early enough, or they would be painful enough that they're not going to be durable. But a lot of them, to your point, will be either because they will survive court challenge, or after everyone has built up the system to comply with it, inertia will carry it through for at least a bit. It will just become normalized as part of
like
what
the
is
zebra
done.
herd theory of regulation.
Right.
Like the lion can't get all of us, right?
Can't get all of them. And, and then of course, the interplay with, say, the Europeans, who are even more aggressive in certain ways. So, there is that scenario. Now, the problem is, from a reputation point of view, if that is in fact what happened, that's incredibly damning to the reputation of the agency. And it's incredibly damning to the sort of mythos that surrounds agencies like the SEC of oh, these are nonpartisan experts who are just there to execute Congress's will. And if instead you have leadership saying, damn, like you said, damn the torpedoes, we're going to cram as many through, they can't kill us all. And, even if they get struck down legally, as a practical matter, people will still be doing what we want them to do. Okay, well, then you have to start looking at independent agencies as different creatures.
Now, Brian, I mentioned in your bio at the beginning that a lot of your public writings have been about the politicization of financial regulation. And, from my readings of your work over the years, a lot of it is focused on, for example, national banks that adopt the policy that we're not lending money to, or even offering deposit accounts, say, to legal gun dealer small businesses or whatever, out of sort of affection for, say, just a woke principle of anti-gun behavior, right? Mm-hmm. Have you seen similar things? I know that's mainly the OCC and the FDIC and the Fed's territory with those, particularly the OCC. What do you detect in the Gensler regulatory agenda as we've seen it so far? Do you detect other rules that strike you as being particularly political? By comparison, like in the Obama administration, there were a lot of people who write about the Congo conflict minerals mandate from Congress, resource extraction, the pay ratio disclosure, all of which were statutorily mandated. But those were of dubious value from an investor perspective, as traditionally understood by the SEC. Have you seen other similarly politically motivated rulemakings? And what has caught your eye the last few years?
Well, okay, the first one's not going to be a surprise to anyone who's listened to this podcast.
Yes. Climate
disclosure, right? And according to at least the reporting at the time, Gensler was actually something of a moderating force, apparently. But that strikes me as one of the most obviously political, in the sense of we want to use securities regulation to regulate something outside of the purview of securities regulation. We want to change the economic calculus of certain behavior to encourage or discourage it. And climate disclosure is a big one. Another one, I guess it's technically, it would be, I guess it's a self-regulatory organization rule that the SEC approved, would be the NASDAQ board disclosure, or board diversity disclosure rule, which strikes me as fairly nakedly political, fairly nakedly aimed to forward a certain political view of what is right and wrong in the trappings of, sort of securities regulation. And the Fifth Circuit's taking that case up en banc. We'll see what happens. But and of course, the SEC, or then I guess NASDAQ, or no, the SEC was the actual party, right? They drew that inside straight of getting all of the Democrats on the Fifth Circuit in their panel. And the Fifth Circuit took it up en banc, so I assume we're going to get a different response. But like that's another case where it's like that just struck me at least as we're trying to forward some other substantive value through the vehicle of securities regulation, and we need to come up with some sort of ex post facto excuse to like get it to sit in the principles of federal securities regulation.
Yeah, another one that strikes me, and I don't know what Jennifer thinks on this topic, but there's another rule that's been sitting on the Reg Flex agenda for several years, the human capital rule, whose contents, to be honest, as a securities lawyer who covers the Corp Fin, and when I worked for Commissioner Pivovar at the SEC, that was my division to look at. I don't really know what the human capital rule really entails. I hear tell that it comes from, quote, the unions. I'm not sure what that really means. I suspect that the rule, which is, again, not statutorily mandated, is presumably dead on arrival at this point. It's hard to imagine whoever President Trump may select to run the agency. I'm not speculating as to who that might be, but it's hard to imagine that you get a majority of commissioners, particularly where Commissioners Peirce and Rueda are still on the commission. I can't imagine that would go forward. But Jennifer, what are your thoughts?
No, I can't imagine that it would go forward either. I was just going to add that there's another reason that it shouldn't go forward, which was towards the end of Chair Clayton's term, there was an update to Reg SK on human capital issues, and we're only a couple of years past that. If the agency is looking, whether it's union focused or not, it behooves the agency to see how the newish rule is actually working after gathering data about it for several years before revisiting the question again. So whether you were a fan of the content of what we would have thought a Gensler human capital rule was going to contain or not, it was entirely premature based on the previous updates to rules covering similar categories of information. And I think that would be the take out of any Trump administration SEC.
So we've talked a lot about the rulemaking agenda. There are other whole swaths of the Gensler legacy that I don't think we've really touched on in any depth yet. And they're related but distinct. There's the enforcement agenda. And I'd like to hear your thoughts on the last 3 or 4 years of enforcement, Jennifer, particularly given your background in that division. But tied into that is obviously crypto and digital assets in general, where a common refrain from particularly the crypto bros, as they're called, has been that the SEC has not moved serious rulemaking in any formal sense. Congress has sat on its hands largely, although a number of rules and proposed bills have dropped in Congress over the years. Nothing's really moved. And so the SEC has sort of operated in this area of crypto, either by regulation, by enforcement, to use the typical derogatory term that arose in the broken windows period, or sort of by the arbitrary ukase of the commissioners or various senior officers of the SEC simply issuing speeches blessing or condemning particular instruments as being securities or not securities in the wisdom of the city fathers. That's a lot I've thrown into that sentence there. So turning to you, Jennifer, what do you think about enforcement specifically? And then both of you, crypto, that's the other topic we got to get to before we close out today.
Yeah, so I'll have to be fair and say I am a former enforcement attorney, but I was a FINRA enforcement attorney, not an SEC one. So, but enforcement was still something I spent 9 years of my life focused on. And taking a look at what the SEC has done under the Gensler administration, we have a tough time. I'll get to crypto in a second, which I think is by far the worst example of regulation by enforcement that, it would be the textbook definition of what regulation by enforcement is. But the SEC's enforcement function has had a number of greatest hits in terms of problems over the past couple of years. The massive number of cases that they have brought on off-channel communications for massive fines. It's basically the agency's full employment act for enforcement lawyers right now, where they can pay their own salaries with it as well. Is problematic in a number of different ways. One, it's using a statute that was put into place for retention of documents when we were writing things on typewriters, and maybe if we were lucky, keeping the carbon copy in our records. It really fails to interact with the way modern business operates and the way that we communicate as modern individuals. Even if you think that that rule is a good one still, the idea that this giant sweep is going to come out and just punish everyone without fail for not following a rule that is nigh impossible to follow is not a good use of enforcement resources. Maybe it's time to revisit the rule. Maybe it's time to provide better guidance. Maybe it's time to make sure that this is something that is really a focus of the exam teams who can work with firms to get them into compliance. But this is not a good example of enforcement. We've also seen the SEC using its enforcement function to further kind of its environmental, social, and governance causes. Many of the cases that have been brought under that rubric are pretty easy cases, and I don't have a problem with them. If you tell investors that you were doing X, you better be doing X and not Y. That's simple. But after they have backed off of the ESG enforcement task force that they had put together, we saw a case come out against Keurig that was a marginal case that charged Keurig with not properly letting people know about the recyclability of their pods. Again, it looks a little political, particularly given the posture of that case. So I don't want to condemn all enforcement. That's not my interest. The SEC has brought many cases that should have been brought. But on the whole, there's been some problems in the enforcement agenda that were even outside of crypto. Now I get to get on my soapbox about crypto. Crypto has been an enforcement forward strategy for the SEC since Gensler has taken over. I've been calling it the enforce first, make rules never strategy, which is the very definition of regulation by enforcement, particularly when industry players, market participants have been asking for rules. And have been asking for pathways to compliance. There have been a lot of cases the SEC has brought for registration violations where there has been no way for the market participant to actually register under the existing rules. And that's just kind of a refrain over and over and over again, including in the cases that they're currently litigating. Whatever you think about crypto, whether you think it's the next big thing, whether you think it's a has-been already and a never should have been, this is not the way that an agency should approach new technology. And it's not the way that the agency has approached it in the past. We've seen plenty of circumstances where there's been a new invention, an ETF, an asset-backed security, where the internet, where the agency is engaged with the industry, tried to understand whether the existing rules fit well, and if they did not, how could they craft new rules that accomplish the same goals of the securities laws, and work together to do so. There's been no indication of that happening here. The agency has dug in and said that the existing rules are good. damn the torpedoes again, as we keep going back to. And that's been a problem across the board. And that doesn't even get into the fact that the agency's claim of jurisdiction over this is entirely too broad. And that by going forward with this type of strategy, it essentially operates as a ban on crypto activity in the United States. Sure, we have crypto happening, but at pretty high regulatory and compliance risk to those that want to engage in the space. That's beyond the SEC's authority.
Yeah, I would toss in another category of enforcement cases that annoys me for sure. I'm going to borrow from the great Matt Levine of Bloomberg here, but there's the everything is securities fraud category of case where, the CEO of a company, kills his wife and the company hadn't disclosed that their CEO was a mass murderer or whatever. And ergo, there's a stock drop and the company is on the hook for fraud. I mean, that's an extreme kind of jokey example, but these examples have been rife. I mean, one of the ones that commonly comes up, a corporation is the victim of a cybersecurity attack by some criminal element. And the SEC goes after the victim for not sufficiently alerting its shareholders that it could possibly be the victim of a crime. Surely I'm being a little bit provocative there in my description of these cases, but that is a category as well that I find kind of obnoxious. Brian,
I will give I agree with that, although I will say that we cannot pin that one all on the Gensler administration. That has been an ongoing problem with the SEC for years. Yes, that point taken there. I was complaining as bitterly about that when I was on the SEC staff as I am now. Brian, do you have thoughts on crypto in general? I mean, it's a broad category.
So I have a few thoughts on enforcement more generally, and then
please.
So, this is part of what I referenced earlier, that part of the legacy of this enforcement activity may be that it's going to be harder for the SEC to do enforcement in the future because, one, the parties that are being regulated understand that there is going to be a cost to rolling over, right? Like, I think part of the reason why everyone and their brother is getting hit with fines for using their cell phone is because initially the big banks that got targeted first reached settlements rather than fighting it out and saying, no, that's not what the law requires, back off. They reached settlements that I'm sure to them at the time were like, oh yeah, look, this is cheap enough. It makes sense for us to settle this, without necessarily realizing what ball this was going to start rolling. And now I think people are going to look at this type of thing and say, well, we better fight it up front or else we're going to be hit up for fines, every 5 years. Particularly that given the SEC's somewhat interesting incentive structure in terms of fines. And then, to the everything is securities fraud and or, some of the crypto stuff, right? If the SEC takes a very broad definition of its powers, it takes a very broad definition of what is a security. It takes the Howey test and it takes a very aggressive view of it. And one of the risks it runs is at some point it comes into court and says everything is securities fraud. And a judge says, well, then nothing can be securities fraud because that can't be, the answer can't be Congress made you a universal regulator of all activity. That just can't be the right answer. And does that prompt the Supreme Court maybe to come in and add another prong to the Howey test? Something like, oh, and the value of the asset must be intimately tied to the financial health of the issuer. Because like you could argue that, in the crypto case, right? Some of these tokens are economically speaking securities, right? Like some of them are. And if the SEC had kind of kept its enforcement to those, it would be a different conversation. But the ones where they're really having to strain to fit them under that rubric, this may prompt a court or Congress to come in and say, all right, we need to add some further definition and some further limitation to what is a security, because otherwise there's the risk that, as the great Matt Levine says, everything will in fact be securities fraud. And Congress I know as a textualist, I'm not supposed to care that much about legislative intent or legislative history or congressional intent, but they didn't mean it to be universal regulation. They did not mean it to be a thing that a creative lawyer near Metro Center near Union Station gets to say, oh yeah, well, we can somehow sort that in. And so if the agency won't show, discretion and circumspection and humility, then the courts and Congress are going to eventually step in.
No, I think that's a good point. And I think that is something to keep an eye on over the course of the next couple of months in terms of enforcement actions that are being settled. We had already seen, particularly in the crypto space, where the SEC, I wouldn't say wasn't aggressive before, but has started reaching even further on some of the settlements. Recent cases on NFTs, like Flyfish Club, where the supposed security was an NFT that offered people the ability to eat in a restaurant. That is a relatively recent case, and I would not be surprised to see some of these more tenuous theories being cemented in kind of last minute out the door enforcement actions that get finalized before the end of this administration.
Mm-hmm. We're coming up on about 45 minutes into this conversation, and I think we've covered a lot of ground looking backward at the Gensler administration, Gensler SEC. Looking forward, imagine that tomorrow an airplane comes to DCA and it picks up Jennifer Schulp and Brian Knight and whisks you off to Mar-a-Lago, right? And you're there with the man himself. It's Jennifer, Brian, you're tremendous people. You say wonderful things about me. This Gary Gensler is a loser. What do I do? What am I supposed to do with the SEC? What are you saying to President Trump there? Looking forward to the next, I think in practice, while you're thinking about that unexpected question and impersonation, I think although Gensler has made some comments about maybe wanting to stay on to the end of his commissioner term and things, I think in likelihood, given the outcome of the election, we'll probably see something like we've seen in previous administrations where Chairman Gensler will vacate his seat. The president will, in any event, on January 20th, will designate either Hester Peirce or Mark Ueda, in all likelihood, to be the acting chairman. We have an embarrassment of riches, obviously, at the commissioner level, because Hester and Mark are both tremendous. And they'll have a 6-month, maybe while we're confirming the new chairman, sort of interregnum period. And then thereafter, it's the sunlit uplands of whoever the new chairman is going to be. What are you telling Donald Trump, President Trump, to do with the SEC? Not individual names, of course, but aside from the purely negative agenda of canceling some rules we don't like from Gensler, abandoning certain avenues of enforcement that we no longer want to pursue. Is there a positive agenda that occurs to either of you that the center right, the libertarian right, the conservative right, the MAGA right even, is there something that they should be pursuing the next 4 years at the SEC?
Yeah, I mean, I think the easy first answer to that is getting the crypto house in order. And the thing that can be started immediately after we have an acting chair under the Trump administration is kind of starting that process rolling, whether that's a request for information out to the industry to kind of function as a pre-proposal to start gathering public comment, whether that is roundtables, whether that is explicitly soliciting ideas. I mean, there's a host of ideas out there already, many of which have been sent to the SEC in petitions for rulemaking. But the easy first stop on that train is getting the crypto house in order, stopping a lot of these enforcement actions that aren't related to fraud or investor harm. But really, it has to be starting the rulemaking process. in getting that rolling. I mean, I think otherwise the affirmative agenda is taking a look at capital formation again, which has been ignored for the past 4 years. Taking a look at how the Clayton changes to the exempt offerings framework have operated and what more changes can and should be made. There were a lot of good suggestions that came out of the House Financial Services Committee this year that passed the House on ideas about fixing parts of the exempt offering framework. So I think that there's an affirmative agenda here, but that affirmative agenda starts with crypto and then continues on to other places that make it easier to raise capital for entrepreneurs and easier for individuals to make their own investment decisions.
So as the quasi-academic I am, I'm going to talk at like a higher meta, more useless level, as is my prerogative. So I think the affirmative agenda and what I would recommend to the president-elect is to pick a chair who understands that the SEC has lost its way and who wants to make it their mission to get the SEC back to where it's supposed to be. And I understand there are some people listening to this who are like, there should be no SEC. Okay, fine. Let's table that for a second. But assuming that the agency persists, assuming the 33 and 34 acts are not repealed, and that is, it has a tripartite mission: orderly markets, investor protection, capital access. There's a lot for an agency to do in those without having to take really ambitious, aggressive views of its authority. There's a lot for an agency to do with those without trying to make itself the environmental police or, the friend of labor or the friend of management, whatever, right? And so looking at why the agency lost its way, who at the agency, be it, people who are political and will be leaving or people who are staff, who sort of facilitated that, and maybe, there needs to be a reconsideration of their roles, and bringing people in who will inspire and drive the agency back to its core roles. And by that, I'm not calling for a do nothing SEC. I'm not calling for a do nothing chair. That's a ton of work. That is a lot of work. And in amongst it, should they be going after frauds? Absolutely. Mm-hmm. Absolutely. Should they be doing rulemakings that are either statutorily required or are necessary within the bounds of the law to maintain orderly markets? Absolutely. But either there has not been enough bread and butter fraud over the past 4 years so that the enforcement attorneys had to go out and take really novel arguments. And to be clear, it's not that in some cases, at least, they weren't making really novel arguments against bad people who were doing bad things. But there are other authorities out there who have much clearer statutory jurisdiction over common fraud. Not everything needs to be a securities law situation. And so bringing the agency back to focus on its core mission, which is plenty important and there's plenty to do, I think should be what someone should focus on. I think it would be a wasted opportunity if we pick somebody who would make, who's just oh, look, I just kind of want to go back to the way things were. It's we don't just go back. We have to actually. We
can't go back as one of the.
Okay. We
have to make securities law great again, Brian. You're on message. I appreciate it.
As you pointed out with and Jennifer pointed out with rulemaking, that is an active process of undoing and redoing. It is not just okay, well, hey guys, we're just going to stop and everything goes back to normal. And so, and that is what I would recommend. See Wallace DeWitt for chair.
No. I wanted it to, so I have a half-written op-ed that's going down that way. So Brian, we're on the same wavelength. I completely agree.
Okay, Jennifer Schulp for chair.
So the way I think
about it, we could be a working
it,
majority. If they're listening, there's 3 of us here. We could totally do this.
Jennifer, if you're not a Republican, then you could be on, it's only political party membership, right? It's not ideological affiliation.
No. When I was a clerk,
talk about ignoring legislative intent. But okay.
When I was a clerk, my judge used to think of all of his clerks as his hunting dogs. and he would tell us routinely, don't go chasing rabbit trails. And the SEC at this point needs to stop chasing rabbit trails and get back on its mission.
I think that's a great point to end on. I think it's also a great title for our podcast today, Don't Chase Rabbit Tails. I look back on the Gensler SEC maybe. For the good of the order, are there any topics, Jennifer, Brian, that we should mention, or any final parting shots that you'd like to get in before we close today?
I mean, there's always shots, but I've had enough.
There's always shots to take. Well, maybe we can do this again in a year as we analyze how the SEC has reacted to the various challenges they face. Well, I'd like to thank again Jennifer Schulp of the Cato Institute, Brian Knight of the Mercatus Center at George Mason, myself, Wallace DeWitt, of course, of Undisclosed Law Firm, and thanks very much to the Federalist Society for giving us this platform today. I'm sure any of us would be happy to field questions by email or LinkedIn or whatever. Thank you.
Awesome. Yeah, thank you all so much for tuning in today. And thank you to our awesome panel of experts for sharing their insights and opinions. Hopefully, some of their advice comes in handy in the next couple of years. But if you're interested in learning more about our programming, discussing the regulatory state and the American way of life, please visit our website at regproject.org. That is regproject.org. Thank you.
On behalf of the Federalist Society's Regulatory Transparency Project, thanks for tuning in to the Fourth Branch podcast. To catch every new episode when it's released, you can subscribe on Apple Podcasts, Google Play, and Spreaker. For the latest from RTP, please visit our website at regproject.org. That's regproject.org.
This has been a FedSoc audio production.